Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll look at 3 questions in relation to resulting and constructive trusts, which falls under equity and trusts in FLK2. Let's dive in. Here's the first question we tackle today. A woman purchases a property by utilizing a 20% deposit given to her by her wealthy friend who is good at property investment, while the remaining 80% of the purchase price is covered through a mortgage from the bank. The property is transferred and registered solely in the woman's name. After 3 years, the property's value has risen, potentially resulting in a substantial profit. The friend now asserts he is entitled to 20% of the property's value under equity. Which statement best describes the legal position? A. The friend would not have a legal claim to 20% of the property's value since there is no evidence of any agreement or contribution towards the purchase price. B. The friend may have a legal claim to 20% of the property's value only if there is clear evidence of an agreement or understanding between the parties regarding their respective shares. C. Since the property was transferred solely into the woman's name and there is no documented agreement or evidence of contribution from the friend does not have a legal claim to 20% of the property's value. D. The woman holds 20% of the value of the property on a presumed resulting trust for the friend, as he has contributed to the purchase price and the presumption of advancement does not apply. E. The woman holds 20% of the value of the property on a presumed resulting trust for the friend based on the presumption of advancement. You can pause the video and think about it. The best answer is D. The woman holds 20% of the value of the property on a presumed resulting trust for the friend, as he has contributed to the purchase price and the presumption of advancement does not apply. A presumed resulting trust arises when someone contributes to the purchase price of property held in another person's name and there is no clear evidence of a gift or agreement to the contrary. The friend is not a close family member, so the presumption of advancement, which applies in limited relationships, like from parent to child or husband to wife, does not apply. Therefore, equity presumes that the woman holds 20% of the value on trust for the friend, in proportion to his financial contribution, unless she can prove the money was intended as a gift or a loan. Let's look at another question very similar to the first question. A woman purchases a property by utilizing a 20% deposit loaned to her by her father, with 80% covered by a mortgage in her sole name. The property is registered solely in the woman's name. At the time of the loan, the father clearly stated that he expected repayment within 5 years, with 1% annual interest. 3 years later, the property's value has increased significantly. The woman now wants to know whether her father is entitled to 20% of the property's value. Which statement best describes the legal position? A. The father is presumed to have made a gift because he is a close family member, so he has no legal entitlement to repayment or property's value. B. The woman holds 20% of the property on a presumed resulting trust for her father, as the loan was used for the purchase price. C. The father is entitled to repayment of the loan with interest under a debtor-creditor arrangement, not a share in the property. D. The father has an equitable interest in 20% of the property based on a common intention constructive trust. E. The woman must transfer 20% of the legal title to her father, as he funded that proportion of the purchase. The best answer is C. The father is entitled to repayment of the loan with interest under a debtor-creditor arrangement, not a share in the property. Although the father contributed 20% of the purchase price, he made it explicitly clear that the money was a loan, not a gift or investment. He also set repayment terms and interest. This clearly establishes a debtor-creditor relationship, not a beneficial ownership interest. While the presumption of advancement would normally apply in parent-to-child situation, it is rebutted by the express loan terms. However, rebutting the presumption does not necessarily create a resulting trust, because a resulting trust arises only when the contributor does not expect repayment and intends to retain a share in the property. In this case, the father did expect repayment, and even charged interest, which shows he did not intend to acquire a share in the equity. Therefore, he is entitled to recover the loan principal plus 1% annual interest, but not a 20% share of the property or its increased value. His remedy lies in contract, not in equity. Here is the third tricky question. A woman purchases a property in her sole name, using her own savings for the deposit and a mortgage in her name alone. Her friend, who had recently lost her job, moves in shortly after completion and pays a monthly sum that is well below market rent. Over several years, the friend takes full responsibility for cooking, cleaning, and managing the household while the woman works full-time. There is no formal agreement about ownership or any rental arrangement. After a falling out, the woman asks the friend to move out. The friend now claims she has a beneficial interest in the property under equity. Which statement best describes the legal position? A. The friend has no equitable interest because she made no direct contribution to the purchase price or mortgage, and there is no evidence of a common intention that she should share in the property. B. The friend has an equitable interest under a presumed resulting trust, as her domestic services amount to an indirect contribution to the purchase price. C. The friend may acquire an interest under a common intention constructive trust if she proves a shared understanding with the woman and detrimental reliance. D. The woman holds the property on a resulting trust in favor of the friend, proportionate to the below-market rent paid and household services provided. E. The friend has a legal right to remain in the property as a tenant because her payment of below-market rent created an assured short-hold tenancy. The best answer is A. The friend has no equitable interest because she made no direct contribution to the purchase price or mortgage, and there is no evidence of a common intention that she should share in the property. Under English property law, an equitable interest may arise through either 1. A presumed resulting trust, based on direct contribution to the purchase price, or 2. A common intention constructive trust, based on shared intention and detrimental reliance. In this case, the friend made no financial contribution to the deposit or mortgage. Domestic contributions, cooking, cleaning, and managing the household, do not qualify as contributions to the purchase price. There is no evidence of any shared intention, express or implied, that the friend would have an ownership interest. The below-market rent and informal living arrangements suggest a bare license, not a tenancy or beneficial ownership. Therefore, no resulting trust arises, and the requirements for a constructive trust are not met. This reflects the principles in Lloyd's Bank against Rossett, 1991, and Burns against Burns, 1984. Without a clear agreement or direct financial input, equity will not infer a beneficial interest in the property. This table summarizes the legal principles. In the first case, a friend paid 20% of the purchase price outright, and the property was registered solely in the woman's name. Since the contributor is not a close family member, there is no presumption of advancement. Instead, equity presumes a resulting trust, meaning the woman holds 20% of the property on trust for the friend, unless she can prove the money was intended as a gift or a loan. In the second case, the woman's father provided the 20% deposit as a loan, with clear terms for repayment and interest. Although a parent-to-child transfer usually triggers the presumption of advancement, that presumption is rebutted here by the clear loan arrangement. As the father expected repayment, this is treated as a contractual debt, not as an investment or gift. Therefore, no resulting trust arises. The father is entitled to repayment with interest, but not a share in the property. In the third case, the friend made no financial contribution to the property purchase. Instead, she paid below-market rent and helped with household chores. A resulting trust cannot arise because there was no contribution to the purchase price. A constructive trust also fails because there is no evidence of a shared intention to own the property and no clear detrimental reliance based on such an understanding. As such, the friend is considered a bare licensee and has no legal or equitable interest in the home. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE 1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.